Hello, fellow Toolboxers. Thank you for joining us for episode 361. It's a regular monthly one we have with Kevin Gregg going over Supreme Court, Federal Court, BIA Court updates by U.S. immigration law and have some fun banter. I always enjoy talking with them, real skilled attorney. So it's worth a listen. It's usually one of the most popular episodes we have every month. Before starting, I want to let you know that our E2 seminar is coming up in a week, January 16th. I think we only have one spot left. If you're interested, email me ASAP to get in on it. It's Thursday, 10 a.m. Pacific time. If Los Angeles doesn't burn down, having said that. So if 10 a.m. Los Angeles time, 1 p.m. Eastern for an hour, we're going to go over it's consular processing for a investment of less than $100,000, frankly less than $70,000 for a small retail store. So it's going to be really interesting to learn about that if you're trying to get into business immigration, which is a must do during the Trump administration. That'll really lessen the pressures, especially if you have a removal practice. So just hit me up, info@immigrationlawyerstoolbox.com. I'll send you a link for scheduling. And if it's filled up, I'll set up another one next month to do it as well, some other kinds of cases. Again, the email is info@immigrationlawyerstoolbox.com. Having said that, the information here is not intended as individual legal guidance. Please consult an immigration attorney about your case, but you all know that already. Hello, fellow Toolboxers. We have our wonderful Kevin A. Gregg Esquire here to talk about federal immigration court cases. As always, welcome New Year. It's going to be reviewing December cases. It's always like a couple weeks after to do the review. But hey, Kevin, how are you? How's the immigration review podcast going?
I am a toolboxer.
And
I am a toolboxer, and proud to say that I am a toolboxer. And
are you
on the immigration review, I do them week up. It's only for your show where we're doing the last month. I have to have some. I got to give some incentive for people to listen to my show rather than just get like all the goodies on your show a month later.
For sure, for sure. So, I mean, it's hard to keep it up consistently. How many years has it been now?
Over 4.5.
Wow.
Over 4.5 years. That'll be 5 years in May. I started in May of 2020. So that'll be this will be my third presidential administration, and let me count because all the cases, the respondent is always the attorney general. So this will be my I didn't have Sessions. Sessions wasn't in yet, but I did have Whitaker. So that'll be three, four. This will be my fifth attorney general come January, come this month. God,
But
at
did you
least I
have
don't have to. At least I don't have to be saying Gates every week.
well,
Maybe I'll be saying Gandhi, but at least I don't have to say Gates.
like so Trump had like three or four or five, but Biden was more consistent, just one, right?
He had two. Trump had two, but then he had two acting, so it was four. And yeah, right. And even the acting attorneys general under Trump issued presidential attorney general decisions, which is wild. It was just Merrick Garland for all of Biden, and Mr. Garland did not really issue any presidential immigration decisions
Very
other than like
peculiar.
five. He issued like five, but four of them were just reversing what Bill Barr and Jeff Sessions did. So
Wasn't there a
it
thing?
was really just one matter of BZR. Matter of BZR was pushing the envelope a little bit.
Wasn't there a thing where during Trump administration where they said the acting attorney general can't issue decisions like binding decisions or something like that?
I'm not familiar with that. Both Whitaker and I don't know if I think Whitaker did. I know acting Attorney General Rosen issued, I think, two presidential immigration decisions, which is wild.
There was something where DHS they said, oh, the acting DHS director can't do it. Yeah.
That was different. So that is because what he did, what Trump did, is he put someone in charge of DHS who was never Senate confirmed in their prior role. And so there was a challenge to the rules that guy promulgated. I can't remember who it was. There were actually a couple of them. He did the same thing with the acting head of USCIS. What's his name out of Maryland? But that was the issue. So you had someone in a Senate confirmed role who hadn't been Senate confirmed previously. But people's for Whitaker and Rosen had been confirmed for other roles, Senate confirmed, I understand. I think Whitaker was a deputy attorney general himself beforehand, for example. And so was Rosen. And so that was okay. But the DHS thing was there were so many acting DHS people that eventually he put somebody in who wasn't Senate confirmed in their prior role. It's just wild. It just didn't care. Just
Well,
didn't
we're
care.
this is the last podcast before the show starts. So not this show, but the real show, the Wild West show of the presidency. We'll see how it goes.
Yeah. But, from my end, I guess the decisions won't change that much. You're still challenging adverse decisions. Maybe there'll be more of them. Maybe not. I don't know. It does seem and this is completely um, without basis other than my own observations, but it does seem like federal circuit courts are more inclined, at least in the immigration context, to find that the BIA erred if they don't think that the administration is operating in good faith. It seems like there were more wins for non-citizens earlier in the Trump years, or but I don't know, And of course, what is going to change on my podcast is I'll start talking about the district court decisions more, which I really don't want to because they are so long and so complicated. And I don't know. We'll see what I do about that because it's too much.
Yeah.
But in the interim, there has been significant Supreme Court precedent on standing, both in the immigration and non-immigration context, that might make it more difficult this time around for states and other groups to sue the administration. Although I think a rule passed the House today, a law passed the House today, which, don't get me wrong, might not pass the Senate, but which would expressly allow states to sue the federal government for immigration actions that impacted the state. I can only imagine that cuts both ways, right? It's
Yeah.
not just Texas and parole. And that's in response, of course, to some of the adverse state rulings that came out of the Supreme Court the last 4 years on standing. We'll see what happens.
No,
We'll see what
I'll
happens.
throw this out there. I finally downloaded and read State of Texas versus DHS, which was the Keeping Families Together decision. And the judge does a really good job going over the history of the INA and how parole works and all this kind of stuff. Because there's always this confusion I had with like 212D parole versus like other kinds of parole where you're like, there's like two kinds of parole. One of them you can't adjust, can. And I still didn't fully get it reading it, but it's like 20 pages. It's a good read. And you
I don't
mentioned
know.
it's a district, but it's a good read.
I don't know. I mean, if you listen to Justice Gorsuch and Jennings v. Rodriguez, there's only one type of parole, it would seem, and it's a 212D5 qualifying one. Or
Yeah,
212D3, or whatever the
yeah. I was
212D5.
it's worth for immigration lawyers to go through this history, especially it's like a just goes through the history of immigration law to a certain extent. So
Yeah.
it's good factual knowledge just to have in your back pocket about that. I haven't finished reading it because I really want to see because the comparison is with parole in place or military parole in place, which they've been doing that for years now, for a decade plus. And so I'm right at the part where they're trying to compare those two. I didn't read after that, so I should make a podcast about it. But then again, maybe have you done this analysis of that case?
Yeah, no, I'm not. I'm not going to spend time. I'm glad you did. We should. I'm not going to spend time reading decisions from district court judges that I'm not quite sure are operating in good faith
Okay.
on issues that the Biden administration is going to give up on because they're a lame duck.
Yeah.
That is the reason I haven't. I'm sure that judge is a smart judge. I
I haven't read the
think that
analysis yet, but just the intro has like factual history of immigration law, and at least I would say 90% I think it's correct. It's just like okay, the INA says that 245 I says that 245 says this, so it's a good primer, just like why immigration law is the way it is. Like there's the INA, then there's the civil code, it's the same laws but different numbers. It's just like for people, it's good to know. I'll probably do a
it
synopsis
is,
of
and I'd
it.
be more inclined to read it if I thought it was going to get appealed. It's not because Biden is out, and I want to just clarify. I mean, I have respect for that judge. I don't know anything really about him other than the fact that these lawsuits are being brought by Texas, not just in the Fifth Circuit, but in a specific couple of venues,
Yeah,
local venues in the circuit. And so Attorney General Paxton thinks that he's going to get wins if he brings these cases in certain venues. And so I do look at some of these decisions with a grain of salt because, again, Attorney General Paxton is. So I'm just following his lead. And so, I'm sure that judge did a great job outlining the history of parole and immigration. I'm not sure it was ever a question that Biden's parole program was going to fail in front of that judge, but I
yeah.
guess we'll never know.
Yeah, I haven't read the analysis. I just read because it was long. Read the factual parts, like 74 pages. So, but I want to read it because I was like assuming if you got pro in place, how did they get knock this one out? President, it's the executive power. Do whatever you want. Let someone in. So I was surprised, but Biden unfortunately waited till the last day of his administration essentially to do this. So like he had 4 years. So that is the thing. Like the Democratic administrations, I think they just use the immigration talking point for votes. But I mean, piecemeal they do stuff. But there's so much more they could have done to make sense of the system for everybody.
I think the Republicans also use it for votes,
Yeah,
and I
it's
think that, but I just think that there's more actual racism in the Republican Party. So there's a genuine desire amongst some Republican lawmakers to keep out foreigners, xenophobia, not racism so much. I think that that's a genuine motivation of some in the Republican Party. That's less so on the Democrat side. I do think both parties are doing things with immigration for votes. I guess it's not mutually exclusive
Yeah, it's a political
in that
football, but
regard.
I mean, because there's like the Democrats are like, okay, are they going to do this? Are they going to help dock people some way or fashion? But it's like they didn't even throw a bone like out there. It's just like, come on now, okay.
Yeah, the February bill didn't even have anything for DACA people, and I wonder with the sincerity of that bill. But ancient history,
Yeah,
new administration. Now we are the resistance again.
yeah. I remember like 4 or 5 years ago when he got elected, I had this hot fire like podcast where I'm like, we're gonna fight him and all this is like so like now I'm like older. I'm like, oh, so let's take it the idea. But okay, let's jump into the cases. Let's do it. So what do we got first?
We're gonna fight again.
Oh yeah,
Just to be clear, I'm older, but we're
it just is wiser
we're
because
already
it's just I know where to waste my energy, where to not, so it has more like you know which venues to put your like energy on. That's gonna have the most bang for the buck.
I suppose the problem now, though, it is a good segue. I've got 4 cases this month, which is unusual. Rather, usually 2 or 3. But
Mm-hmm.
if the Supreme Court speaks, we got to talk about it. The Boarfa v. Mayorkas et al. Decision, and that is kind of the segue. Is we are going to fight again under this administration, but there's a different Supreme Court, and Patel has now been issued, and the talk of the not the talk, the theme of the Supreme Court, I suppose, over the last 4 or 5 years in immigration has been limiting jurisdiction of federal courts to entertain anything.
Mm-hmm.
Wilkinson's a bit of an outlier, but even that is deferential review. And here we have Boarfa relying on INA Section 242A2B double I to prevent review of USCIS's decision to revoke an I-130 petition for any basis, in this case based on a subsequent 204C finding. So Miss Boarfa had an I-130 approved for her husband, and then later USCIS decided that that husband had attempted to engage in marriage fraud, or maybe had engaged in marriage fraud previously, and they revoked the approved I-130 petition. Now, the question was whether or not Miss Boarfa could then sue in federal court, because they were, of course, strenuously arguing that there was no prior marriage fraud. I don't know if there was or was not. There are no facts developed. Now it's interesting. 204C is mandatory. If they find marriage fraud, actually I don't want to get this wrong. Is 204C? Yes, 204C is mandatory, I believe. If they're adjudicating an I-130 and there is, marriage fraud that occurred, they shall deny it. And so if it's mandatory, the argument is it's not discretionary. And so even the Solicitor General in Boarfa conceded, and the Supreme Court very much seems to have blessed, that an I-130 denial based on a 204C finding is reviewable
Yeah.
in federal court, because 204C is mandatory, and on the other hand, an I-130 approval is mandatory if they, meet the qualifications. But the decision to revoke an I-130, or really an I-140 petition, and by the way, I think there was a First Circuit decision or maybe an Eighth Circuit decision a few weeks later applying this principle to the I-140 context. It's the same petition revocation statute. I want to get the language correct, exactly correct, because it's very important for this. USCIS may at any time for what the Attorney General or the Secretary of DHS may at any time for what he deems to be good and sufficient cause revoke the approval of any petition. Supreme Court said because that's discretionary, even though a 204C finding is mandatory, because that's discretionary, there is no review. Because INA Section 242A2B II, and kind of as interpreted broadly with Patel, serves to bar all discretionary decisions by the government, which is it's a wild thing.
Yeah.
Because again, this exact issue, the 204C in connection with an I-130, is reviewable, but USCIS can insulate itself from review if they decide to approve and then revoke. Pretty wild, right?
Yeah, it's a ridiculous decision. It just puts people in a really just rescission and revocation are just like so annoying. It's like
It's a ridiculous decision. It's a unanimous decision. Unanimous, no dissent, no
yeah,
concurrence. But that's because, well, I have no idea why, but Justices Sotomayor, Kagan, and Jackson have made very clear that they respect stare decisis, and the holding in this case does follow decisions like Patel and Guerrero Lasprilla and Wilkinson, all of that. So I'm not saying it was required, but it's not astonishing. We filed an amicus in this on behalf of what this would do to revocations of, say, an I-140 petition in the EB-5 context, or maybe not the EB-5 context, but or with EB-5 petitions. I mean, any petition is
yeah.
potentially at play and unreviewable. And that, in the employment categories, there's hundreds of thousands, if not millions of dollars at issue, unreviewable in federal court. It's pretty wild.
So how do you deal with it then? Like you do a BIA appeal on an I-130 that's been revoked, or just then file a new one, have that denied, and then appeal that?
Well, it's both. So you can absolutely, as happened here, file a BIA appeal. It's just once the BIA denies, you have federal court redress because they're not going to put you in removal proceedings, or if they can, that you can get no redress on the petition in removal proceedings because only USCIS, as you know, can approve or deny such things. But yes, as the Supreme Court indicates here, Ms. Boarfa filed a new I-130 petition. USCIS will deny it with the 204C finding, and then she can challenge that at the BIA and then challenge that in federal court. So really, you've just created a bureaucratic nightmare and more years. And if it's if the removal proceedings are going collateral, if USCIS initiates removal proceedings right when they revoke an approved petition, for example, and then alongside removal proceedings, you need to file a new petition, have that adjudicated, go to the, you're just adding time with a collateral proceeding that has incentives to get sped up. It's they're counter, they're in competition,
Yeah.
those two incentives, and it's a problem.
I had a colleague call me actually over this 203 yesterday, and apparently, so there was a marriage case, 203C finding, and then the person like didn't challenge it. 10 years go by, child becomes 21, and they file for an I-130 for them, and the I-130 is approved. I was like, shouldn't the I-130 have been denied based on the previous 204C finding? But I guess now they're thinking whether to adjust status or not, or how to reopen and do that. I'm like, I was under impression for that you have to do a BIA appeal. And then add to that, someone on a Facebook group said they got one of these fraud findings, and the USCI is set to file a I-290B appeal. And I always thought I-130s go to BIA. They don't do I-290 appeals. So I was kind of confused on procedure. I never done this.
I'm not sure. I mean, I know that you can go to the BIA. I'm just not sure if you also have the opportunity to file a 290B. It sounds like a waste of time and
Yeah.
money unless you've got a really good 290B, you can put in new evidence. Appeal to the BIA, theoretically, you can't. So that might be one reason if it's available.
Mm-hmm.
I have a feeling you can. It seems like you can 290B anything, but
Yeah, I
maybe
mean,
not.
because you could do a motion reconsider potentially from the same officer, just say, hey, you missed
Yeah.
something. So, but it
Yeah.
procedurally, once the 204C finding, that's like a hammer that hits you. That's the last thing you ever want. Because I've seen people come to me with I-130 denials where they just didn't think it was bona fide, but they didn't. And when you're reading the decision, they don't make a 204C finding. And I always wondering, like, is this considered fraud or just like? So I just tell them refile, and I've just in the consult, I was like, they didn't find a finding. Just have more evidence and go do an interview again and have it go.
If they don't make an express 204C finding, then they're not 204C barred. But in a subsequent filing, absolutely, you need to act as if the agency, as if everything's on the line,
Yeah,
and you need to what I advise. You need to relitigate that last one too.
yeah,
You need to submit proof that the last one was valid and the current one, because they're itching to make a
Yeah,
tool for.
big
See,
time. In that case, could be one of those that gets stuck for 3 years on Island 30. You're like, what's going on? So it's like a bad news train, one of those.
yeah.
But it pops up pretty frequently, and it's going to be probably more and more in the administration. So it's good to know the details on how to deal with that.
The other ones, of course, are my regular good
Yeah.
cases, but having spent a lot of time on BARF, I'll go a bit quicker. Lopez Quinteros v. Garland out of the First Circuit on December 13th, 2024. It's just, I mean, I love the case because it essentially stands for the proposition that even if you got one of these gang-based asylum cases where the gang from Central America or the gang is extorting the husband, that's like so often what's
Yeah.
happening, right? Even if that's not viable, it's not happening for the right reasons, not on account of any political opinion, particular social group, religion, etc. Even if that's not the case, if that gang then turns their sights on the spouse or the child, for example, of that husband, you might have an asylum claim. You might have a family-based asylum claim, particular social group. That is what Lopez Quinteros v. Garland stands for. That is what happened. That is why there was a remand. And let me get the quote for you.
What circuit?
Now, whether the alleged persecution is family-based ultimately must depend on the extent to which the record shows that the family status of the targeted person drove the decision to target that person as a means of obtaining money that the targeted person had no legal obligation to hand over, end quote, i.e. extortion. If they think the husband is rich or has money because the husband's got family in the U.S. or because the husband owns a business, blah, 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 the husband refuses to give up the money, and then they target the wife, as happened here, not because they wanted that wife to give them money because they think the wife has money, but in an effort to pressure the husband. The First Circuit is saying you very well might have a particular social group nexus and an asylum claim. And oh, by the way, the husband, of course, can be the derivative beneficiary on the
Perfect.
wife's case in that circumstance. And so cases like this, very important. Lopez Quinteros v. Garland goes against
What circuit?
some of the decisions that have been coming out of the board of late on family-based particular social groups, including under Attorney General Garland's BIA, but Circuit trumps BIA
Which
always.
circuit court is this?
This was the First
Okay.
Circuit. But there are similar cases out of the Fourth and the Ninth offhand, but this one's pretty direct. Pretty direct. This was pretty explicit. The husband doesn't have a claim. We understand the gang just wants money. The wife still might have a claim. That's a big deal.
It's just imagine living your life, being a family man, and all this kind of stuff. There's like a million stuff with business and kids, and you have to worry about. Then you have to be worried about being extorted from people, like giving money or
No,
like what a annoying thing I have to deal with in life. I mean, geez.
annoying is a milk toast word for
Yeah.
it. I mean, your issue, my issue is with the five protected grounds. I mean, what are we doing? Why is that? Why do you have to fear death for the right reason
Yeah.
to get protection? I understand that we need to limit. Well, I understand the theory that we need to limit immigration to America. You can't just open the floodgates. And if you start with that premise, then you need to have limiting principles. But the five protected grounds seem just so arbitrary.
Mm-hmm.
And of course, if you get killed, it doesn't matter to your family why. You know what I mean? I
Yeah.
mean, it is cold comfort. Having done about 3,000 of these decisions over the last 4.5 years, it starts to become a bit crazy talking about life and death and
Yeah.
technicalities.
I mean, I'd move my family to the U.S. and that's if that happened to me, why not? Like, it's a no-brainer. Like, get out of here, yeah, if you can. Oh man.
Singh v. Garland out of the Ninth Circuit. I'm not gonna lie, this one a bit wild. Is what it is. First of all, Singh v. Garland. I don't want to upset the Sikh community. I have Sikh friends. It seems like every Sikh's last name is Singh. I don't understand. This is like the 15th Singh v. Garland decision that I've had on the podcast, and they are all Sikh-based asylum claims. So if there are other last names besides Singh in the Sikh community, it must be an insignificant percentage because this is, I mean, it's wild. Is literally the 15th Singh v. Name Your Attorney General decision I've done on the case in 4.5 years, but also that's indicative of what's happening to the Sikh
Yeah.
community in India. And this one is actually not a Sikh This is not a Hindu Nationalist Party versus Man Party Sikh claim. This is actually a intra-Sikh
Mm.
dispute. The Man Party and the Badal Party. More importantly, though, Mr. Singh was deemed not credible the first time around, and it does seem like he did lie, quite frankly. But this is a motion to reopen where there's a previous adverse credibility decision, but his claims are distinct. If you recall, they passed those farmers' laws in India in I think 2019, and there was a lot of protesting. And Mr. Singh came in and said, maybe it wasn't 2019, I don't remember when it was, but Mr. Singh said, my family's a farmers, all of these new bases for asylum that are separate from his past claims that he feared the Badal Party. And the BIA essentially said, well, you were not truthful before. You haven't overcome the fact that you weren't truthful before, matter of FSN, so denied. And the Ninth Circuit says you cannot do that. You have to, and the Ninth Circuit has really good case law on having to believe affidavits unless it is, quote, inherently unbelievable, end quote. So in adjudicating a changed country condition motion to reopen in the Ninth Circuit, and honestly, I just read FSN again. There's a lot of this from FSN. The agency can't just say you weren't credible before, so you're not credible now. If the non-citizen comes with a new story that isn't inherently unbelievable, and with some corroborating evidence, they don't need to overcome that adverse credibility finding. It might be hard. There's a line to walk, and it would probably be best, just like in the 204C thing you and I just talked about, to probably show how you weren't lying the first time. But very big deal out of the Ninth Circuit. Singh v. Garland on December 24th, 2024, not to be confused with the 14 other Singh v. Garland decisions I've done. It's a big deal for motions to reopen where there's a prior adverse credibility decision. Because again, the BIA is going to come at you with matter of FSN, and this is a decision for how to distinguish it.
Very cool. That's good to have.
There's that. The final case is Quinto Guachechulca v. Garland, published by the 8th Circuit on December 9th, 2024. This is about the aggravated felony definition of rape. I'm not going to get into the specifics or all of the nuance of that argument because it is kind of gross. There's no need. But I have this very issue pending on petition for review of the 11th Circuit right now, and so I am all ears. And I just must note that the 5th, the 6th, and the 8th Circuits, arguably three of the four least progressive immigration circuits in the country, have all held that the BIA was wrong in matter of Keeley in its definition of rape, and that rape has a narrow definition. I'm not going to talk about what these circuits are saying is excluded from rape because it's gross. Read the decisions. But here's the 8th Circuit coming in and saying, no, the board is wrong again. Statutes that criminalize digital or object penetration using one's fingers or an object, that is not rape under INA 101A43A. And quite frankly, most states now do criminalize such things because such things are terrible. And they want to criminalize more people, but that is outside the federal definition of rape, has said the 5th, 6th, and now the 8th Circuit. Hopefully the 11th Circuit too. We'll see. Maybe I'll be on your show lamenting how I lost the case at the 11th Circuit. It's a big deal, though. It is a big deal that these circuits are saying, and it shows how powerful the categorical approach is in crimmigration. And I will also say, I'm arguing this at the 11th Circuit right now, and these circuits aren't bringing it up, but it's this whole zombie precedent issue that I've been beating for the last couple of years that I took from Jeff Hoffman and David Isaacson, this concept. There are like a dozen BIA decisions, matter of Keeley being one of them, that have been reversed or vacated by a circuit court on direct petition for review. It is my position that those decisions no longer exist. It's not the same thing as a circuit coming and disagreeing with it when, let's say one circuit relies on matter of Keeley to decide the case in, matter of Gonzalez. This is the circuit that vacating the decision where there is no more final agency decision. I don't think that the BIA can continue to apply its vacated or reversed precedent in other circuits. Now, none of the circuits have ever brought this up in their adjudication, so I'm probably wrong, but I don't see why, and I've never been told by anyone why I'm wrong. So we'll see. And we should all keep arguing this issue. There's like over a dozen zombies, over a dozen BIA decisions adverse to non-citizens that have been vacated or reversed on direct petition for review. Matter of Keeley is just one of them.
Is this
So,
like a recent phenomenon that's happening, or the last 10, 20 years? Is that something?
like 20 years. It's been happening forever. And I have pause because, like, at this point, there have probably been 100 circuit judges and 300 very smart federal appellate law clerks who have seen an issue like this and not come up with the same theory I'm saying. That gives me pause. For example, this Eighth Circuit decision talks about why matter of Keeley was wrong. Matter of Keeley was reversed by the Sixth Circuit in Keeley v. Whitaker 6 years ago. Why is the Eighth Circuit talking about matter of Keeley? Why do they even think it exists? Same thing with matter of GGS. The Ninth Circuit, which is you can't consider mental health issues in the particularly serious crime context, for example. Now, Attorney General Garland got rid of that with matter of BZR, but before that, the Ninth Circuit vacated GGS on direct petition for review. I think the case was Gomez, Sanchez v. Sessions, I believe, something like that. But then, like, 3 other circuits analyzed whether GGS was right or not. Why? GGS had been vacated. So those are just some examples. I must be wrong if nobody else has identified this.
Well, sometimes in life,
But I don't
everyone's
see
wrong and
why.
you're right. It's not always that way. I mean, maybe.
I have never had that experience. I would love to have that experience. But I'm not saying I'm right. At this point, I would just like to be told why I'm wrong.
I mean,
At this point, it's just intellectual.
could it be because just immigration is like this ugly stepchild theory of law where they don't know how to deal with the situation? Because like the clerks probably don't deal with immigration that much. So like, what's a BIA even like?
No, absolutely not. There is BIA precedent, and the legal concept is it's like circuit collateral estoppel or something. It's just agency. It's administrative law. I've even reached out to administrative law professors, and they can't give me the answer. But the BIA is just like an administrative agency. And maybe most administrative agencies don't issue new rules through case-by-case adjudication like the BIA does. I guess that's kind of rare, right? I can't, like the EPA, their rules happen through notice and comment rulemaking. That happens with DHS too, but I actually am not aware of other agencies that issue their rules through case-by-case adjudication like the BIA. I know they exist. So maybe that's one of the reasons. But there is precedent, and it makes sense that one circuit shouldn't be able to tell the other circuit, shouldn't be able to essentially enjoin application of a BIA precedent in all the other circuits. That's a non-offensive, mutually exclusive collateral estoppel or something. It makes sense.
Yeah.
But if they vacate the decision, they have taken away the forum by which the BIA is speaking. There is no, if the BIA is doing case-by-case adjudication, and that's how they're announcing new rules, what happens when that case goes away?
Yeah.
Right? Matter of Keeley itself was remanded to the immigration judge after the Sixth Circuit ruled. The BIA's Keeley decision does not exist.
Yeah. If you remand the start
So
over
how?
again, yeah.
Nothing would have stopped the BIA from taking another case at the time outside of the Fifth or the Sixth Circuit and reissuing Keeley and saying this applies in every circuit except the Fifth and the Sixth. They could have done that.
There are
I
what
don't
I can't
disagree.
remember which ones that they've done that where like this decision is here, but doesn't apply in like this circuit or something. There's
They have
yeah.
done that, and it used to be that they could say it even applies in the other circuit, and that was Brand X. But now that Chevron's dead, so is Brand X, and they can't do that anymore. But maybe they can. I don't know, but they can't do it with Chevron deference. But if they haven't done that, they can't. Cannot be the case, as was the case in my case, that an immigration judge sitting in Miami says, "I'm not going to listen to your arguments because I'm bound by matter of Keeley." That can't be right. Matter of Keeley doesn't exist anymore. But nobody is making that argument. So I'm probably wrong. I just want to know why. And then I want to win on my second argument. Anyway, the Eighth Circuit didn't address that, but they did agree with what is my second argument in my 11th Circuit petition for review about the federal generic definition of rape. So it's an interesting decision, Keto Baltachuka v. Garland. All praise to the law school and law professors who got that very important win, as with the matter Keeley v. Whitaker itself. Very big things happening in some of our nation's law school clinics.
Yeah, I mean, last time around, the Trump administration caused a lot of law schools to make clinics and students to sign up, and that's probably going to happen again. The field like grew dramatically because of the administration, so we could probably see another batch of new blood coming in as the older heads get tired.
Donate,
What's that?
donate to the ACLU.
Well, good stuff, man. So
Yep.
we're wrapping up. So that was 2024 in a nutshell. Are you going to do a recap of like the most important cases of 2024? Have you done that already?
I have not.
Do you feel like doing that?
I haven't. I think I did that 1 year. I'll do it if I have no cases in a given week. But I don't think that doesn't happen. That happened. That has happened like once. It was like Thanksgiving 2023. I had no cases. So there's always something. I'll probably do a roundup pending interesting
Yeah.
cases if I have a slow week.
I used to do an annual review
But they
of
are
big changes in immigration law, so I like keep track of every change, kind of like what
yeah.
the Kurzban does. But after a couple years, I'm like, oh, so much work, like to go through every single change, and decided it was worth it, so I gave up
So
on that. They were good episodes. People like to watch those, but I was like too bogged down in work.
it has been Ira's life.
I mean, he's nonstop immigrant because I'm doing it like a tenth of what he's doing, or maybe a 20th, and it's like nonstop. I can only imagine he's all the time immigration nonstop.
All the time.
Well, it's good. It's a good practice area for it. It's interesting. It's just all consuming if you want to do it like that. I can't imagine like his brain is just immigration constantly. And with Trump administration coming, he's going to
Yep.
be like double fold on already like full.
Oh, it's even worse. So he just published, what is it, the 19th edition of the book? I'm trying to look at it right now. I think it's the 19th edition. He had spent so much time putting in the new Trump and COVID rules in the 18th edition, only to take them all out for the 19th edition, and now he's going to probably have to add them again for the 20th edition. I mean, not the COVID stuff, hopefully, but and that's just wild. Like,
I mean, he could have it as an addendum for like in the future, something like that happens. You have a reference of what happened during that time, like if it happens again, maybe or something. I don't know.
well, no, but if it's up to date,
Yeah,
it's not about the history. It's about
that's
being up
true.
to date on immigration. And if you have different administrations flip flopping like that, I mean, then he's just essentially doing. He himself is also flip flopping with thousands of pages of regulations. This is
So
wild.
I got to jump to my other podcast conversation, but one thing I had a client come in asking about military citizenship and stuff like that, and I researched it. And ACLU, Steve Miller came and said, if you join the military, you can't automatically file for citizenship immediately. You need like 6 months to a year. That was like a rule they wanted to change. Got sued on, I think ACLU sued and won. And then the Biden administration at that point was in. They said, okay, we'll redo the policy, give us some time and hold our appeal. 3 years go by. Last November, they said, actually, we're going to keep the Trump policy and we're going to file an appeal. So that's going to be an appeal that's going to happen for military Nats. So just a heads up, that's going to be a big decision. I kind of fell into this rabbit hole and I realized there's like a lot of people, I guess, that this will affect that join the military and want to file Nats immediately.
Yeah, imagine that'll be Supreme Court maybe 2026.
Yeah. So we'll be talking about that. All right, Kevin, thanks a lot for coming on the show, your brother. Glad to have you another year. It's It's been years that we're doing this now. Our friendships and the years
Here,
now.
it's I'll be in Denver, by the way. I haven't agreed, but I'm going to agree to the honor to speak at Ayla National if you'll be there in a couple
Yeah, I
months.
gotta go. It's a big responsibility and it's expensive. It gets more expensive every time, but it's like you gotta go. What are you gonna do? It's such a good time.
It's
Yeah,
fun too. It's fun to talk to the
for sure.
to be with everybody.
For sure. So I like yeah, we're both in Southern California, but we'll see each other in other states every year.
That's right. Hey, Southern California is big. It's San Diego to LA is the same as Miami to Orlando. So
Yeah, they're
you know,
complete.
people don't get that.
As a family, we do go there. Actually, no, we're gonna go to Legoland, and then every time we go to Legoland, we go to San Diego for like a lunch or late lunch or something like that. But we try to get to.
Well, I have yet to receive a text message. That's on you, my
You don't
friend.
want three little kids coming in. You already got a little kid. You got your hands full. You have three more of them coming. It's gonna be too
Right.
much. But
That's
as
true.
they all get bigger, we'll try to do something. Especially if you move up more north, we'll try to connect it.
No way, man. LA scares
Yeah, I'm trying to move out myself. Go to some more suburban area, just more land
me.
around me. All right, bro. Good seeing you. I'll catch up with you next month. Go.
Bye.
Bye bye. Thank you so much for listening. Kevin is so thoughtful coming on the show every month for a couple of years now. I think I've talked to him in my life, one of the most amount of people, if you really calculate the amount of time we've been talking. And I've learned so much, and I hope you have as well. It's a real treasure having these kind of friendships and these kind of personalities in the community. You really, we have the magazine has come out. I've been talking about too much, but a new episode of the Immigration Lawyers Toolbox magazine came out. Not a new episode, new issue. So we're going to be doing a lot more issues. Instead of trying to get 20 articles, I'm going to try to get like 7 per issue, so it makes it more easily manageable to produce these. So if you have talent, you know something about the immigration space, other lawyers don't, hit me up, propose a topic, and we'll try to get you in so you can help improve the field and promote yourself as well. We try to work on that part really well for you. Just give us some good information, some good content so we could help the community. Having said that, if you're interested in the E2 investor course, invest in less than $100,000 concept processing, send an email and I'll send you information on that. Get started. info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyerstoolbox.com. Hope to see you next time. Bye bye.